Good morning. Good morning, everyone. I'm very happy to be here and to talk about ecological law and modeling with scholars and people, lawyers that are already very so empathetic with the team, because normally we have some difficulties to explain the relationship, the internal relationship we have between law and economics, and which doesn't mean at all law and economics as, as a theory. I always underline it to my students. We are very far from this, but so I'm happy with what I have heard already, and then despite of my difficulties with the language, I will try to explain you something that I start to develop, looking for immediate or concrete and activity that we lawyers and the law scholars can already implement regarding ecological law efficacy, and also trying to put in this basket kind of a principle that we have already talked. We are really starting to talk more and more. That's the principle of living in harmony with nature, because it's really this principle, this idea, let's see, is inside the UN platform of rights of nature. And then I think we as law scholars could start to manage to bring on board an ethical principle that could fast be developed into a legal principle. And as we have already had with sustainable development and principle and the precautionary principle, all of these principles started as an aim, an objective, or a moral idea, but the jurisprudence and the law decisions and lawmaking process had made it a legal principle. I think in a very fast way, if you consider the time that normally law spends to integrate new values. Then I think faster we could also have a help for this change of paradigm that has been talked about for many scholars have been talking about it, Klaus Bosserman and all these people that are connected and sympathetic with Elga. So this change of paradigm in terms of law, the role of law requires new legal principles, and that points out new legal aims and vision. So one thing is this necessity I forcing to have stabilized a new legal principle that could orientate our juridical thoughts. Another thing is to have immediately tools in terms of building concretely this ecological law view. And then I come to the idea of this paper, which is to have the activity of modeling inside the law reasoning in all its aspects during lawmaking process and law interpretation and law decision by judges. So just to start, I say that environmental law and environment economics tend to treat the environment and nature as an array of natural resources. So the picture we have on the left side, this perspective precludes the possibility of a harmonious relationship between humans and nature. This intrinsic bond we have because we live all together, connected with nature and printing our our footprint on this small, beautiful planet. So ecological law envisions regulation of human-nature relationship in ways that constrain human activity within ecological planetary boundaries. So a paradigm change in ecological law, just as it has been made in ecological economics, is necessary. Environmental law had one of its first principles, which is called the polluter principle. So if you take the beginning of environmental law in the early 70s, so the first important legal principle, we took it from economics, which was the principle of the polluter pay principle, the polluter pay. This principle has been developed by an economist, a liberal economist called Ronald Coase, and it has been spread in environmental law throughout all the natural resources regulation. We can see that in water regulation, in climate regulation, in biodiversity regulation, forest regulation, and in the end, even in climate regulation within the Kyoto Protocol. So I take this principle to symbolize what we don't want anymore. So we have the polluter pay principle because of a pre-orientation that nature is a component with a square, just like this one in the picture. This is with natural resources. It comes from, if you take the international law and the idea of natural resource in international law, it comes within the problems of colonization and the decolonization process. So we took the expression, the legal expression, natural resource management, from the discourse, the idea that has been flourished during the 50s regarding the decolonization process. And the natural resource was taken in the legal discussion, during the legal discussion, as the point for property. So who belongs the natural resource, the ex-colonies or the imperialist countries. And then came the UN resolution about the natural resources use. And then we took all this idea from so the two ones I'm pointing out, the liberal economic idea of polluter pay principle, and as well the idea of natural resources exploitation from not very clean source, would I say. So it came already from a problem of origin. And we try in the ecological law to fix it and to turn around to rebuild a perspective of law that is ecologically integrated. And continue. So we have to put something else in the place of these two problems: the legal principle problem and the natural resource exploitation perspective. Regarding to the polluter pay principle, we had read the criticism that came just after Ronald Coase's book, paper, The Problem of Social Cost. William Kapp wrote The Social Costs of Private Enterprise. This book is very important because it makes the denaturalization. It shows that the so-called negative externality is not something natural that comes always with the human process of production. It is something related to a kind of production, a very carefully chosen kind of production. And then we don't have to take this externalities, the so-called negative externalities, as something that is given for granted, but something that is inside an historically very well organized form of economic production. So that's the reason why he called his book the social cost of private enterprise. It's a way of organizing the exploitation of natural resources and the labor that make it possible to talk about negative externalities. I just point out this two sides to stimulate the possibility to think out of the frame we have already have when you talk about economics. All these things regarding related to natural resource exploitation, the polluter payer principle, and the negative externalities, all these things are theoretical developed, and you have to look to these things and to make a kind of a deconstruction in order to make real this change of paradigm. So at this slide, I say that ecological law should transcend merely limiting human encroachments of nature as environment law does. When you talk about ecological law, we have a view to demonstrating the potential of its potential. I take the modeling in order to highlight the dynamic systems-based perspective on how the making and interpretation of law can interact with social and economic paradigms in complex ways that affect human-nature relationship. So by incorporating this synergy that underlines a holistic understanding of systems, sophisticated systems-based models can reveal implications of future scenarios with a high degree of certainty. So the modeling approach is a way to have a system-based approach with the most holistic implication of a single act. Then the complexity of the object of ecological law requires much more than a simple adjustment of an action to a specific law command. An action is compliant with ecological, so how can we say if an action or an economic activity is compliant with ecological law? If we could show or prove that a set of related actions and involvement elements of nature respect the necessary maintenance of ecological systems in the present as well as in the future. So models can provide a better idea of the legality of an activity projecting its results into the future. We make it as an ex-ante approach instead to consider the reparation and compensation aspect that in terms of ecological law can give us very few. The legality of the use of models. So why should we take it? So we can, with models, respond to basically to these three questions about the distributive justice, about be complying with legal principles, and also give us a better picture if someone during his activity is complying with their legal obligations in terms of ecological protection. So, giving you another more concrete example, I would, for example, the already well-known rights for present and future generation. We have that for decades in our law, but we don't know exactly how to do with this And then what I try to put it, how modeling can highlight a dynamic system-based perspective, and in order to show if some activity is respecting future generations' rights. Because to know more about that, you have to know more about the whole system and the consequence of the activity. For example, the picture, we have a plantation, and you have a high irrigated area. When you see it in a country, for example, like Brazil, that is, until now has lots of water, you say, oh, it's okay, we have a lot of water, you can do this. But it's completely wrong if you take it in terms of the vulnerability of the water system, of the local communities, of and so on and so forth. I'm not going to describe all these elements involved, but what I'm trying to say is that just like as the Climate International Association makes in terms of projecting the future when something moves on, for example, the temperature increase. So all this big picture that we can design can show us about the legality of an activity. Last one, do I have some? So the other example I gave is how to be compliant with the precautionary principle. So we have misleading this principle, in my view, because of the statement that stays in the UN Rio Declaration, which was to be just a pure example of how to apply the precautionary principles, became the concept of precautionary principle, and it is very narrow. If you think about precaution, we have much more to think about than the scientific certainty. And the best way to apply the precautionary principle is to have this holistic understanding of system. Well, concluding, modeling can show us a useful tool to enforce sustainability because it can project future impacts, enable policy and lawmakers to shape appropriate policy and rules, and can help us adapting the expected behavior of agents towards environmental protection goals in an efficient manner. Thank you very much. Sorry, I forgot the last one. That was, I can just let it there if you want to see it. So how can we use it in terms of law? So I think Kevin. Yes. When I talk to you, you were talking about law and the possibilities of law activities. So my last slide I couldn't show properly shows in this different aspect of a lawyer's activities how we can apply models.
There, well, we have our 5 minutes of questions.
Well, I think this is a very interesting topic where I'm trying to imagine. I've done some modeling, and maybe if I could just give an example that I can think of and see if it's what you're talking about. So we looked at a case of the Kaibab Plateau is kind of a ecological, very interesting place because it's kind of, you know, it's kind of it's sort of a land island. I mean, it sort of has natural barriers. So there were populations of deer and their predators, coyotes, cougars, and that were contained there. And when it got populated mostly by settlers, they started killing off the predators to protect their farm animals. But then what happened is that the deer population went out of control, and it was reaching a collapse scenario. They got overpopulated and they didn't have food. And so they were coming up with strategies on how, I mean, this is a human-caused problem, so what are human-caused solutions? And so what this modeling did, say you have a law that you know, requires the reintroduction of a certain number of predators, or that puts that allows a certain amount of hunting. So you could test out putting in the outcomes or the expected outcomes in the law of how that would overlap on the ecological model. Is this the kind of thing?
I thank you for your example. It's absolutely that. And our history about environmental compliance is full of this kind of example. With the worst result we could have. During ELGA meeting, they came with something also similar. It was the wolves population and the sheep creators.
The sheep breeders, they are killing wolves.
Yeah.
And that's the thing. And then there was a question, well, if you're talking about living in harmony with nature, how can you manage that? I said, it's easily, so not easy, but ideological easily, because we have to start thinking out of this squared natural resources scenario, and this, as you said, Jeff, man recipes for man problems, so anthropocentristic recipes for this anthropocentric view of natural resources. And I think taking modeling can make us organize better our holistic thoughts. Because the modeling is that the best thing, the best solution? I don't know, but I think it's can be a useful tool to make us open our minds beyond the idea of natural resources and help us to solve a situation like that you put.
Yeah.
Yeah, I won't say anything after this. I'm asking too many questions the last while. I think it's fabulous what you're doing, absolutely fabulous. And it really opens up, as you say, a whole new way of thinking about things. In a way, it's kind of an environmental impact assessment in reverse.
Exactly.
Right? and which is what's needed. I have two questions about it. What sort of things go into the model? You talk about ecological impacts, but I think there's a portion missing. It's got to be socio-ecological impacts, because it's always the human is involved in doing this and is affected by it. So if it's looking at modeling the future, the human is a big role in that. The second question is what scale, right? The scale of it. So, for example, I represented Greenpeace for years in a bunch of international negotiations, including the London Dumping Convention, dumping of waste at sea, in the early 90s when Greenpeace was really pushing the precautionary principle. I have never seen arguments and fights in international negotiations that anywhere approximating the fights on the precautionary principle. Scientists literally just yelling at each other. and now Obama's science advisor hated the precautionary principle. It's so meaningless and it does this and that and the other thing. So, yeah, he was just his original. I don't know if he stayed with it. He hated the precautionary principle. So the question to me is, when you scale it up, when you look at what goes into it, and you scale it up, I think it's like opens up a whole new world. But it encounters a lot of problems. So what goes into it? What sort of considerations go into it to address what is a really entrenched existence? I mean, for example, they've caveated the precautionary principle by sticking that phrase, the original precautionary principle, with cost effective. Right? What cost-effective measures, right? Rather than just whatever needs to be done. So how would you look at it as a real system changer at a larger scale?
Well, the second question is really difficult. I try, but first of all, I'm very thankful with your first question, because I spend a lot of time in Cambridge talking with lawyers, explaining them that is exactly the reverse logic of environment impact assessment. Because when they look at, but this is environment impact assessment. I said, no, it's exactly the other way around. So I'm happy that you have understood it, because it's difficult to show that because of this reversal logic. Then I think just to answer it, yes, exactly that. It's not to make this logic of I want to do something, then let's see what's the impact of my activity in this region and how to mitigate. And no, it's nothing related to that. And because it's something prior, and something that is going to orientate if you can do this now, and also for the future, and regarding the position of your activity within a global system. That's the point. But the second question is a very tricky one, but a very important one. And is the thing that I want to fight for. So, because how to scale it, I think it's a political choice. Because when you talk about an holistic vision, a change of paradigm, a living in harmony with nature, all this beautiful expression demands something to be scaled. And that was my challenge, to put some scale on this beautiful expression. And one thing, and that was the reason why I put the precautionary principle as an example. One thing we have to adjust is to explain this precaution, that is something that manages our private way of doing things all the time. And we have to put it in a real world as a necessity of acting within planetary boundaries, of acting as a part of nature that has the right of living as well as other life beings have, does that. And first thing is to deny the principle was trying to find out here the wording of the principle and the UN Rio Declaration, to deny it as a concept, but take it as an example. This thing related to the scientific certitude is one thing that we take as precaution. So if you you are not sure about the scientifically proved consequence of something, you have to take care and to exercise precaution. It's one thing, but it's not the thing. Precaution is much more than this. And conceptualizing this principle in terms of ecological law means to have at least a broader idea of the dynamic of the whole system. That means precaution. So to scale it, when I put this picture about the plantation, how to scale the impacts or the consequence of this activity in terms of the ecological systems now and in the future. How far shall I go to the future? All these things, the modelers at the IPCC are used to, lawyers not, but the modelers are used to. So then the scale can be done politically, scientifically, but it's very important to make a broader picture, and also give different models according to different scales we give, and choose the one. So
you're kind of flipping the precautionary principle as well, in the sense that let's build systems that by their natures are achieve precautionary objectives built into them, rather than having to restrain the system with precautionary principle. We actually create systems that empower the precautionary principle.
That's perfect. Great. Absolutely. Yeah, that I like it. I will right, because that's the idea. That's the idea, and that makes the difference between environmental impact assessment and the models, because we are improving options. You are doing options were precautionarily thought. When you get this.
When you talk about systems too, I mean, the law is linear. I mean, it's like such a linear system, and our economic development models have been a linear system, But yours is more of a kind of dialectical in a way, right? So dialectical as full systems. So
yeah, that's
a great thing. We'll continue later.
Thank you again, Christiane.